Hi, so in this podcast we look at the general principles of certainty of intention, which is one of the first three certainties that need to exist to create and express trust. Just a bit of a reminder on how these podcasts are structured. You'll see in the heading there that it says Topic 2, Creating Express Trusts, Subtopic 2.3, Fundamentals. So this is the law bit. So the next four podcasts, 2.3 to 2.6, deal with certainty of intention. And then we have the kind of application of all this. So we have worked examples coming up after that, and then a critique of this area. So looking at the main themes. So where it says fundamentals, we're dealing with the law. Where it says worked examples, we're dealing with either multiple choice questions or problem type questions. And then if it says topic 2.3 critique, then we're dealing with a critique of the area. So without further ado, what are the general principles when it comes to certainty of intention? Essentially, there are two ways of establishing this intention to create the trust. Either there is an express verbal or an express written intention to split the ownership between a trustee and a beneficiary. And when we say written intention, that's covered by a trust instrument, for example. So you've gone to a lawyer, lawyers put together a document setting out that you want to create a trust. It could also be an express verbal intention, and that will suffice for everything except for land, because you can't create a trust, an express trust for land, unless it's done by deed in writing and witnessed and so on. The other way is that you haven't been express at all, but rather the courts have objectively implied an intention from your words and conduct, or words or conduct. So the easiest thing to do, as we've discussed in a previous podcast, is to just get your lawyer to draft a trust instrument, whether you want to create something over land or whether you want to create something over cash. That doesn't need to be done in writing, but everything then is set out clearly and everyone is aware of each other's obligations and rights. Now, for the purposes of the remainder of these podcasts into intention, we're assuming that doesn't happen. So in other words, we're looking at what happens if there's no trust instrument. And it's really important that you know the kind of default law, what the law would be like if there was no default instrument. So what we're looking at is the courts objectively determining whether your words, conduct, and the context amount to that intention to split up the ownership. And that's kind of that formulation of an objective determination is there in a whole load of appellate decisions, Westdeutsche Landsbank from 1996, Schoenestra and Yardley from a bit later on, Paul and Constance, Court of Appeal from the 1970s, more recently North and Wilkinson from about 2017. So you could have an email, for example, that doesn't use the word trust, doesn't even consider that, but just says something that amounts to a splitting of ownership. So for instance here, I want you to look after this car for Jim's use and only Jim. So look after implies that you're putting this in that person's, giving that person the legal title of that. But then you're doing that in order to allow only Jim to have use of that car. So not even the trustee. So in this kind of situation, we say that equity will step in and say that it would be unconscionable to hold that anyone else could have an interest in the property, that no one else could have an interest in the property other than the person you're writing the email to, because clearly the intention of whoever's writing this email, the settler, is that they want to benefit Jim. So here's a couple more examples of actual cases where the context and the words and the conduct have contributed to establishing a trust. So the first is Paul and Constance, which I've talked about before in previous podcasts, but I talk about in a bit more detail here. So the crucial ratio, if you like, of the case is there must be clear evidence, according to Lord Justice Scarman, one of the real kind of heroes of common law. Those of you interested, for example, in race relations, he wrote a really, really important report into the Brixton riots in the 1980s. He was a real progressive and trailblazer, as well as being an absolutely brilliant judge. There must be clear evidence from what is said or done of an intention to create a trust. So they're not going to imply a trust lightly. So here we had a situation where a boyfriend who was married won some money, and he had a girlfriend at the time. He wanted that money to be used, according to the evidence, by both himself and his girlfriend. So they went to the bank and tried to open a joint account. This being the 1970s, however, it wasn't possible. You could only bank managers told them, sorry, we can't open a joint bank account for you because you guys aren't married. So he put the money into a new account, his account, that he created in his name. So the money was in his account, therefore he's the legal owner of the money. But he said on many occasions, this money is as much yours as it is mine, and indeed they used it for joint things like holidays and so on. So the man passes away, and his wife gets to know about the money, and his girlfriend obviously knows about the money, and there is a court battle between the two. Justice Scarman and the Court of Appeal said, well, we can see that it would be inequitable, given everything that's happened, to just say that this money belongs to the boyfriend. Because clearly, had the rules been different, it would have been in a joint bank account, which implies that it's there for both their use. And there's also evidence that even after they were rejected for a joint bank account, it was clear that the money was going to be used by both and was for both. So to translate that into sort of the triangle of settler, trustee and beneficiary, one thing you could say is that the settler and the trustee was the boyfriend, and the beneficiary were the boyfriend and the girlfriend, because he said this money is as much yours as it is mine. So he's not holding it just for the girlfriend, he's holding it both for himself and for her in equal shares. So that's an example of where the context, the conduct, objectively determined with strong evidence, will demonstrate an intention to create a trust. Note, these guys had no idea they were creating a trust. They probably didn't know what a trust was, and the word trust was not used, but it amounts to that splitting of ownership. And that's why we need to know the default law and not just the fact that you can go to a lawyer and put everything into a trust instrument. Another example is taken from the business world now. So it's not just ordinary people who don't know what a trust is. It's actually business people whose contracts may have amounted to a trust. Now, I should stress this case, Northern Wilkinson, it didn't amount to a trust, but it nearly did, because in the High Court they found that there had been an intention, but here they found that it didn't. And I suppose the most important point to note is simply that, again, the courts aren't worried whether or not they've used the word trust or not. Indeed, here they did, but they clearly meant it in a kind of everyday sense, like, I will trust you with this, right? Which is not a million miles away from what a trust is in law, but it's not the same thing. Anyway, let's go through the facts of this and what was decided, and you can see what I mean. So one of the parties was a sole trader. So in other words, though, he wasn't using a company or a partnership or anything else. There was no sort of business, no kind of corporate vehicle. He was just trading as a sole trader. And he designed a very clever engineering tool that made him ultimately a lot of money. The other parties had invested in that business, and according to the agreement that they signed with the inventor, which was amusingly called a contract of agreement or an agreement for contract, which was, a bit of a tautology. They contributed a set amount, and it was known how much they would get out of the profits of the business. The rest of the agreements were not binding according to the court, because they were just agreements to agree. And as you know from contract law, an agreement to agree is not a contract. And indeed, many aspects of that agreement, if you like, were incoherent. Now, an American company had breached the intellectual property of that sole trader for that invention. And as a result, he sued that company in America and won a lot of money. Now, the investors said, well, we have a trust that was created between us and the sole trader, so we agreed to establish a trust over any other money that the sole trader, the inventor, would have gained in the future, and that included damages. And High Court agreed, and they established that there was a trust. But here they said there wasn't, and the reason they said it wasn't is because they couldn't make out from the initial agreements that there was anything that addressed future cash flows that didn't come from the business itself. And secondly, they couldn't identify any further agreement or understanding whereby the damages that they would get would be held on trust by the sole trader for the investors. However, the point is that it could have done, had those understandings been more clearly stated, not in terms of using the word trust or settler or beneficiary, but if they'd actually said quite clearly, future monies will be held by you for our benefit, or something amounting to that, that would have been a trust, whether or not they liked it, whether or not the inventor liked it or not. So, the kind of moral of the story is we have an intention if objectively we can determine whether or not the conduct, the words, the context clearly establishes the existence of a trust. And that was the case in Paul and Constance, and it wasn't the case in North and Wilkinson, even though it might well have been had the contracts been a bit less incoherent. In the next podcast, we look at a bit more about the certainty of intention, and we focus on scenarios that kind of look like they could be trusts that actually aren't trusts. So these are kind of false friends, if you like. So I hope that's been useful, and I shall hopefully you benefited from that, and hopefully you'll benefit from the other podcasts on certainty of intention, and there are 3 more to go.